much. Good afternoon or good morning. Welcome, everybody, depending on where you're at. My name is Jay Anstine. I'm a compliance officer with a radiology physician group located in Colorado. And just a little bit of additional background on me. I've been in healthcare for about 20 years. Have worked on both the provider and managed care side of the market. Have worked for large health systems of a couple 100,000 employees and smaller physician organizations of about 20 employees. And have worked in the industry that has spanned HIPAA from living in a world before there was HIPAA, and then lived through the implementation and then, of course, some of the revisions that have come up over the past few years. And so what I wanted to do is just to talk about just HIPAA and the front office staff and some tips for safeguarding protected health information and some strategies that you can do relative to addressing potential patient complaints, and then also what it might look like if you are the recipient of a government investigation or audit relative to a HIPAA-related issue. So with that, let's go ahead and get started. Just an overview of where we're going to go in the next hour. We're going to talk through, just to kind of level set and tee up the rest of the discussion, we're going to talk through just briefly some background on HIPAA and the 4 rules of HIPAA that we're going to take into context with regards to front office staff. Then we'll shift gears and talk specifically about some strategies for safeguarding protected health information. And then also just a consistent process for handling a patient complaint, if that should come up. Then we'll also talk through some enforcement trends recently and what the federal government is taking a look at relative to potential HIPAA violations. And then, of course, I'll leave some time open at the end for any questions that you might have. So just taking a look at some background on HIPAA. Obviously, it's been around for about 20 years now. I included the site up there for you. You know, I'm sure as many of you all know this law, it's been around for a number of years, and the original intent when Congress had passed this was to advance a couple different goals. One was to allow individuals to maintain their health insurance as they were changing positions or changing jobs, leaving one employer and joining another. And then also was helping to sort of usher the provider community into the electronic age by providing some accountability requirements as it relates to using health information in electronic format. So that was really the original goal of HIPAA. It is now, you know, looking back over 20 years, has changed a little bit because just the dynamics with which healthcare is delivered today in the information age. You know, back in 1996, you know, the internet was around, but certainly was within its infancy. Email was kind of barely around. Texting certainly did not exist. Social media certainly did not exist. And so over the years, we've had to now adapt some of these new changing technologies to and what is somewhat of an old law. Looking at the 4 basic rules of HIPAA, I just listed them up here. We're going to kind of go through each of these. But I wanted to at least make mention that, you know, these are the 4 rules that you're going to want to pay particular attention to relative to your activities with regards to front office staff and making sure that they're safeguarding protected health information. So taking a look quickly at the privacy rule, this is going to address how health information is going to be used and disclosed, as well as providing certain rights and control over health information to the individual. And I listed some examples up there. One I do want to point out with regards to patient complaints and patient rights is the fact that patients do have the right to make a complaint directly to the OCR or the Office of Civil Rights. So that's something, we're going to talk about this a little bit later, but that's something you're going to want to keep in mind as it relates to addressing potential issues and then educating your staff as well. Under the privacy rule, the big thing that we're looking at here is PHI. I included the definition there from the regulations. The big thing I want to point out here is just that last bullet point, which is anything that reasonably identifies the individual is going to constitute PHI. And so that's a very, very broad term and broad standard. And so when you think about things like sticky notes and scratch pads of paper that front office staff might be using to take down notes as they're talking with patients over the phone, those potentially technically are PHI, and so that information would need to be safeguarded the same as it would if it was maybe a face sheet or discharge instructions or maybe part of an actual medical record. And to kind of help define what is PHI, I think it's also interesting to, or important, I should say, to also take a look at sort of what is not PHI. And so there's three main categories of information that does not constitute PHI under HIPAA. The first one is FERPA records. FERPA is just shorthand for the Family Educational Rights and Privacy Act. This is basically very similar to HIPAA. It's just relative to education records for students. And so one thing that is included in there is student health records. So if you do work with educational institutions, you may run into this. There's certain exceptions that you need to make relative to educational institutions with regards to disclosing and using information. So that's something I wanted to point out. Employment records is another one. So this can be a fine line. You know, if it's employment records that are for employment-related purposes, those are not going to qualify as PHI. So a common example that tends to come up as it relates to the employment setting is if an if an employee happens to go out on a medical leave. Any paperwork in terms of forms that the employer requires to be filled out, or policies or applications or anything like that that's going to be relative to that employer making an employment-based decision, those are not going to constitute PHI. If it's maybe an application for short-term disability insurance or something like that, that might be another example. Now, the flip side to that is it doesn't just give open access to employers to look at medical information for employees that are going out on a medical leave. So if it is just truly medical information, it's not something that is required to make an employment-based decision. Maybe, for example, maybe specific medical information about why the person is going out on a leave, or actually accessing medical records of that employee that's going out on a leave to verify information. That's something that would count